Applicants for green cards are not required to leave the United States in order to get their green card, despite news articles and even USCIS press releases saying that. Now, the USCIS memo that's out now about the green card process, specifically called adjustment of status, is written in extremely aggressive language. It calls adjustment of status, quote unquote, extraordinary relief. And it frames the process as something where applicants are bypassing consular processing, which is getting your green card outside the US. It's phrased in a way that applicants are almost getting away with something they shouldn't be getting away with. But a lot of what's in the memo is not binding legal authority. Adjustment of status or getting a green card inside the United States is built in the Immigration and Nationality Act. Congress wrote it, Congress passed it, and Congress has amended the Immigration and Nationality Act multiple times. Despite that, adjustment of status has always been an option for people seeking a green card inside the US. Now, adjustment of status is also a discretionary form of relief, meaning that an immigration officer who's reviewing a green card case has to balance the positive factors in your background versus the negative. And what this new memo does is identify to officers various factors that they should put heavy weight on when doing the discretionary analysis. If you've overstayed your visa, that is now explicitly a negative discretionary factor. If you fell out of status while your adjustment of status application was pending, officers may weigh that against you too. So there is a valid concern here about this memo, and adjudications could become inconsistent as these factors are applied differently throughout various USCIS field offices. Now, the memo is very new, and what's being reported is that officers who are now looking at adjustment of status cases are asking applicants a few questions. They're asking applicants why they chose to adjust their status rather than pursuing consular processing. They're asking why a person may have overstayed their visa if the case involves a visa overstay, and what prevented them from going back to their home country, and also whether there were any factors that prevented them from getting their green card abroad rather than inside the US. So at this point, your category in which you're getting your green card, your immigration background, your overall history, all of it is really on the table. It's important to remember that this memo was written purposefully to intimidate people, to prevent people from moving forward with their immigration cases, and to really create chaos. But remember that the impact of this memo is a lot more narrow than it all is suggesting. Adjustment of status is still absolutely an option, but it is more difficult now. So it's important to talk to an immigration lawyer about it and recognize that this memo is new, so everyone is still understanding how it's going to be applied. For more immigration news and information, feel free to give us a follow.